Impeachment in the United States is the process by which a legislature's lower house brings charges against a civil federal officer, the vice president, or the president for misconduct alleged to have been committed. Impeachment may also occur at the state level if the state or commonwealth has provisions for it under its constitution. The Federal House of Representatives can impeach a party with a simple majority of the House members present or such other criteria as the House adopts in accordance with Article 1, Section 2, Clause 5 of the United States Constitution. Most state legislatures can impeach state officials, including the governor, in accordance with their respective state constitution. Most impeachments have concerned alleged crimes committed while in office, though there is no requirement for the misconduct to be an indictable crime. There have been a few cases in which officials have been impeached and subsequently convicted for crimes committed prior to taking office. There have also been cases where a former official was tried after leaving office. The impeached official may continue to serve their term until a trial yields a judgment that directs their removal from office or until they leave office through some other means. Federally, a two-thirds majority of the senators present at the trial is required for conviction under Article 1, Section 3, Clause 6 of the Constitution. The impeachment proceedings are remedial rather than punitive in nature, and the remedy is limited to removal from office. Because all officers in the federal government are confirmed in the Senate, officers appointed under the Appointments Clause of the Constitution may also be disqualified from holding any other appointed office under the United States in the future. Because the process is not punitive, a party may also be subject to criminal or civil trial, prosecution, and conviction under the law after removal from office. Also, because the conviction is not a punishment, the President is constitutionally precluded from granting a pardon to impeached and convicted persons. Article 1, Section 2, Clause 5 of the United States Constitution provides, "The House of Representatives shall choose their Speaker and other officers, and shall have the sole power of impeachment." Article 1, Section 3, Clauses 6 and 7 provide, "The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of two-thirds of the members present. Judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment and punishment, according to law." Article 2, Section 2 provides, "Shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment." Article 2, Section 4 provides, "The President, Vice President and all civil officers of the United States shall be removed from office on impeachment for, and conviction of, treason, bribery, or other high crimes and misdemeanors." The Constitution limits grounds of impeachment to treason, bribery, or other high crimes and misdemeanors, but does not itself define high crimes and misdemeanors. Congressional materials have cautioned that the grounds for impeachment do not all fit neatly and logically into categories, because the remedy of impeachment is intended to reach a broad variety of conduct by officers that is both serious and incompatible with the duties of the office. Congress has identified three general types of conduct that constitute grounds for impeachment. Although these categories should not be understood as exhaustive, high crimes and misdemeanors, in the legal and common parlance of England in the 17th and 18th centuries, is corrupt activity by those who have special duties that are not shared with common persons. Toward the end of the 18th century, high crimes and misdemeanors acquired a more technical meaning. As Blackstone says in his commentaries, the first and principal high misdemeanor was maladministration of such high offices as are in public trust and employment. The phrase, high crimes and misdemeanors, was a common phrase when the U.S. Constitution was written and did not require any stringent or difficult criteria for determining guilt. but meant the opposite. The crimes are called high crimes because they are carried out by a person in a position of public authority, or by misusing the position of public authority they have been given. It does not mean that the crimes themselves are unusual or higher types of crime. The phrase was historically used to cover a very broad range of crimes.